Hello friends, welcome back to my channel. Friends, today I will discuss the decision of US Supreme Court that was passed today wherein they have discarded race as a factor in college admission process. The case is SFAI, that is Students for Fair Admissions versus President and Fellows of Harvard, and the second case is SFAI versus University of North Carolina. Firstly, a brief info about SFAI. SFAI stands for Students for Fair Admissions. It's a non-profit group whose purpose is, and I quote, to defend human and civil rights secured by law, including the right of individuals to equal protection under the law, and to allege that a student's race should not be a factor to harm or help that student to gain admissions to any competitive university. They filed separate lawsuits against Harvard University and University of North Carolina. They alleged that University of North Carolina, hereinafter I would refer to it as UNC, discriminates against white and Asian American applicants, whereas Harvard is biased against Asian American applicants. They alleged that these admissions programs that discriminated based on race are violative of Title VI of the Civil Rights Act of 1964 and the Equal Protection Clause of the 14th Amendment. Title VI of the Civil Rights Act is a federal law in the United States that prohibits any kind of discrimination, whether based on race, color, or national origin in programs or activities that receive federal financial assistance. It applies to both public and private entities, state and local governments, educational and medical institutions, and any other organization that receives federal monetary assistance, which could be in the form of grants, loans, etc. And the Equal Protection Clause is a part of the 14th Amendment to the Constitution of the United States, and this clause ensures that all individuals are entitled to equal treatment under the law, regardless of their race, ethnicity, gender, etc. Affirmative action in the United States refers to various policies and initiatives of the government that are aimed at providing and promoting equal opportunities for groups which have been discriminated against and marginalized historically based on race, gender, ethnicity, especially in the areas of education and employment. Now, friends, in this case, the main question before the court was whether the admission systems used by Harvard College and UNC are lawful under the Equal Protection Clause of the 14th Amendment. Every year, more than 60,000 students apply to Harvard and less than 2,000 are admitted, which showcases the extent of competition that is there to get into Harvard. The court found that throughout the admissions process, race is also one of the factors taken into consideration while deciding whether an applicant should be granted admission or not, by guarding against inadvertent drop-offs in representation of minority students compared to previous year's representation. These universities measure the racial composition of their classes based on the categories if an applicant is number 1 Asian, number 2 Native Hawaiian or Pacific Islander, number 3 Hispanic, number 4 white, number 5 African American, and number 6 Native American. The court found that these categories are not complete in themselves. For example, they group all Asians together and do not consider whether South Asian and East Asian students are equally represented. And I quote, "If at some point in the admissions process it appears that a group is notably underrepresented or has suffered a dramatic drop-off relative to prior year, the admissions committee may decide to give attention to applications from students within that group." The court found that the admissions program of Harvard and UNC are not in alignment with the guarantees under the Equal Protection Clause because they lack measurable objectives to grant admissions, and they use race in a negative manner. However, the court stated that race can be construed in a narrow way by reading the applicant's discussion of how race affected his or her life on their college essay while admitting students to college. The court observed that a student must be treated based on their courage, determination, abilities, skills, experiences, and not based on their race. The court observed that the universities have for long wrongly focused on race as an identity rather than skills built, challenges faced by a student while the colleges were granting admissions. The Supreme Court ruled in favor of Students for Fair Admissions, that is SFAI, by a 6-3 majority in UNC case and a 6-2 majority in Harvard case because Justice Jackson recused or excused herself from hearing this case as she had served on the board of overseas at Harvard. The court overruled the affirmative action policy of considering race as a factor during the admissions process to raise the number of underrepresented minorities in the college campuses. The court found that the admissions program of Harvard and UNC cannot be reconciled with guarantees under the Equal Protection Clause of the Constitution. Justice Sotomayor dissented and stated that this decision rolls back decades of precedent and momentous progress. She also stated that equal educational opportunity is a prerequisite to achieving racial equality in the country. Justice Sotomayor read a summary of her dissent aloud in the court as a mark of her displeasure. President Biden called this decision as a severe disappointment and that our colleges are stronger when they are racially diverse. Through this judgment, the Supreme Court overturned the case of Grutter versus Bollinger, wherein it was stated that race could be considered as a factor in admissions process because universities had a compelling interest in maintaining diverse campuses. Since 2003, after this decision was passed, this decision has been the guiding principle for all colleges and universities while granting admissions. Today's ruling would end the ability of universities to consider race as a criteria while granting admissions. Friends, this decision will definitely have a dramatic long-term impact and bring about a change in the manner in which students will be admitted at these universities. It's time for us to wait and see how the universities will be dealing with this ruling in the upcoming admission processes. Friends, I hope you liked the video. Thank you so much for your time, and I'll see you soon with another video. Till then, goodbye, take care, and have a great day.